Good afternoon. Happy Wednesday. I saw a post in Earl's community page about CJ Grisham, and it was a link to a video. CJ says that he is representing a client pro bono in a criminal action in Harris County, Texas, and the charges were dropped and the firearm wasn't returned. There was a firearm that the gentleman was carrying, who CJ is representing, at the time of the arrest, and it was taken by the police, and it was not returned. So, according to CJ, he filed a motion for the return of the property, and he got it heard like without it being said or anything, which is interesting. I mean, every court does it different, so who am I to say that's wrong? But the judge, after listening to his argument is that Code of Criminal Procedure Section 18.19 states that, except under various circumstances, like if it's an illegal firearm or if he's a prohibited possessor, or God, what was the other one? If the firearm was stolen, then it had to be returned, I think. That was the argument he was making. I don't know. I watched it yesterday. Anyway, so now he wants to file an appeal, to appeal that order by the court. The court just flat out denied it, right? Just flat out denied it. Now, you can donate or not. Either way, it's not an issue to me. I just figured that you might want to know some cautionary words from me about whether or not you should. And like I said, I'm not going to say you should or shouldn't, but I can at least give you some information that maybe you don't have. Number one is you should never trust an attorney. Now, the only caveat to that is you should always trust your attorney, but you should never trust an attorney who isn't your attorney. And CJ Grisham is at least representing himself to be an attorney, so do with that as you will. And I include myself. Don't trust me. Verify what I say. Inspect what you expect and all that fun stuff. Number two is the question of whether or not CJ Grisham is an attorney. And that's an open question. I don't have an answer for you. On the one hand, CJ is representing himself as an attorney. He's stating that he's representing clients. He's holding himself out on social media as being part of a law firm and being the lead attorney for his legal defense fund thing. So that's pretty good indication he's an attorney. On the other hand, the Texas State Bar website does not return any results for CJ Grisham being an attorney or being anything. No results come up for CJ Grisham, or Christopher J. Grisham, or any other combination thereof. So that might be operator error on my part. Maybe I'm not smart enough to operate the Texas State Bar's attorney search on their website. It could be an issue where they haven't updated their website with current information. Or it could be an issue where he has some sort of a temporary license or permit to practice law for that specific case, or under the direction of another attorney or something like that. I don't know. But just be aware that the Texas State Bar's website does not show that CJ Grisham is an attorney. So that's a caveat. The third cautionary tale is that he did not provide any real facts. I'm not saying it's impossible, but I struggle to believe that when faced with a statute as blatant as the Texas Code of Criminal Procedure Section 18.19, that a judge would flat out just say no. Would just say, no, I'm not going to give him the gun back. Judges, for all their failings, I think try to administer justice. I think try. Doesn't mean they always succeed. They're human. They do have some vested interest in doing justice and following the law. Number one, if they want to get reelected as judges, that's a good incentive for them to not blatantly violate the law. And number two, if they want to move ahead in their career as a judge and become a judge from the Court of Appeals, if they get overturned a lot, that's going to impede their nomination for or appointment to the Court of Appeals. And number three, if they get overturned, it's just more work for the trial court. The appellate court will typically remand to the trial court with directions to proceed according to the Court of Appeals directions. And so then the trial court basically has to reopen everything and redo everything, and it's just more work. And I find that government employees typically like to avoid as much work as they possibly can. And so, yeah, I strongly suspect that the judge wouldn't just say no. So CJ could really do himself a favor by providing a copy of the transcript where the judge explains the judge's decision orally, or a copy of the statement of decision, or both. The statement of decision would be where the judge writes down the underlying rationale for the ruling, for the order dismissing the motion, or denying the motion, I should say, which leads me on to my next point, is that CJ could also just flat out be wrong. I mean, when we get that underlying fact pattern, as blatant as Code of Criminal Procedure 18.19 is, there may be other instances besides what is listed there in 18.19 where a judge would be correct to deny the return of the firearm. And you'd have to look at those particular statutes. But for example, if the gun was used in the commission of a crime. Now you're going to say, oh, but the charges were dropped. Well, the charges for whatever CJ was representing the guy on were dropped. But is there some other ongoing case or investigation where that gun was used in the commission of a crime? And it might have been used in the commission of a crime before CJ's client possessed it. And I'm not saying that this happened. I'm just saying this is a possibility of where the judge might say, no, you don't get the gun back because the gun was used in the commission of another crime in an ongoing case, yada, yada. Or, for example, and again, I'm not saying that CJ's client has this, but if someone is a restrained party under a DVRO and they are not allowed to possess firearms, I'm not saying own firearms or have a concealed carry permit. I'm saying to possess firearms, which is different than owning firearms or having a concealed carry permit. But if they're a prohibited possessor, it wouldn't do anyone really any good for the court to say, okay, here's your firearm back. Bailiff arrests this man for being a prohibited possessor of firearms in possession of a firearm, And a domestic violence restraining order isn't a criminal issue. You wouldn't have a criminal record for it. So the guy might not be convicted of anything, but a domestic violence restraining order is still a restraining order, and violating it is still violating a court order, and it's a crime, and you can get arrested for it. And whatever the punishment is in Texas, I don't know. But you can see why there might be other statutes where there might be other reasons besides what's listed in 18.91 where a court might say, no, you don't get the gun back. And finally, there's no accountability. There's no accountability for how CJ uses the money or not. You don't know who the client is, so you can't ensure that the money was used for the client. There's no fee agreement between you and CJ Grisham. The funds are going into just general donation accounts. They're not going into like a GoFundMe specifically for the appeal of this particular case. It's not going into an attorney's trust fund for the use in this particular case. It's not going to a family member who's going to pay CJ Grisham for his time in doing the appeal. So there's no accountability. There's zero accountability. So you don't know if you give CJ money, you just don't know how that money is going to be spent. Now, I'm not saying that he's not going to spend it on what he says he's going to spend it. He's a staunch advocate for the Second Amendment, and he's probably donated a lot of his own time and money to getting Texas's carry laws to be where they are. And I don't want to take any of that away from him. I'm just saying that there is no accountability. You don't know. I'm not saying he will or he won't. I'm just saying you don't know. So you don't know if he's an attorney. You don't know if he will spend the money. You don't know if he's on the case. You don't know if he's right or wrong. And he hasn't provided any of the obvious things that could give you an idea, i.e. the statement of decision or copy of the transcript, of whether or not he even has a case to appeal in the first place. Because you got to remember that CJ Grisham appealed his conviction, his misdemeanor carry conviction from back in like 2014 or 2015 or whatever it was. And he lost on every single ground he raised in the appeal. So I'm just saying that he could be wrong. You know, we're all fallible. He could be wrong, and he might not actually have good grounds for appeal. And we don't know until we see something along those lines. So I hope this was helpful. Once again, I'm not casting any aspersions on CJ at this point. I don't know a lot of things. So, and if I don't know, you don't know. And if nobody knows, then, you know, inspect what you expect. Thanks for watching. Have a great day.